Brothers and sisters, let us open in prayer the second Sunday after Trinity. O Lord, who never failest to help and govern them whom thou dost bring up in thy steadfast fear and love. Keep us, we pray, under the protection of thy goodly providence. Make us to have a perpetual fear, humility, reverence, and love of thy name. Through Jesus Christ our Lord. Amen. Well, we begin a real peculiar study here with criminal law. It's the third edition by Perkins and Boyce. It was used in a law course that I took on criminal law with a saintly old 84-year-old federal judge. It was absolutely wonderful. He never missed a heartbeat. You ask him a question, go over, find 3 or 4 books on a shelf, and they'd pull them off, and he'd pile through the books at relevant points. His memory was activated, and he'd get around to answering the question. But we're talking about the law of homicide thanks to some of the posts by Dutch Gilson in Twist House. He's posting a lot of the English reformers who were burned at the stake or killed. And of course, there's Old Testament examples of that as well. It comes under the crime of against persons, that is the law of homicide. We think of Moses, who killed an Egyptian. They're almost going to kill Joseph, but he was rescued and sold off into Egypt. We think of Stephen the martyr. In the New Testament, James, the brother of John, and then the apostles who were victims of first-degree homicides. I think we'll see. We want to elevate and consider and think. What I liked about law, this took it for a couple of years, courses, full time, was the carefulness in thinking and the pondering and sifting of the facts and the careful definition of this, that, and the other. So let's start our maiden voyage. It's about 100 pages. It'll take several. I don't envision reading other law books, but as it has a bearing on our field, law comes under the rubric of systematic theology and soteriology. It comes under Old Testament, some of the laws, and then they're repeated in the New Testament. Killing and taking a life, and we're out here in contemporary theology talking about abortion, sodomy, the crummy education system. So let's start with these 2 professors. What is the definition classification? Homicide is the killing of a human being by another human being. And right at the outset, that rules out suicide, although it gets attached to this chapter. Homicide, yeah, this book is loaded with footnotes. We won't read them all because they're case laws. The older authorities gave this definition. Homicide is the killing of a human being by a human being. Now, they're going to talk about justifiable homicides in defense of your own life, national defense, and the like. But we're looking for the unjustifiable homicides. For example, Queen Mary and King Philip the murderers. The difference between the 2 definitions above is that suicide is excluded by the first and included in the second. So the second, older definition is just simply one human being killing another human being. In that definition, that would include suicide. The other, more restrictive definition is the taking of a human life by another human being. You can see how that's more narrow, and that excludes suicide. Well, we might want to think about Judas, who went and jumped over a thing and hung himself in the New Testament as suicide. The problems of self-destruction are so different from those involved in the killing of another, it's desirable to use suicide and homicide as mutually exclusive terms. The trend is towards excluding suicide in the substantive criminal law, and homicide is not a consideration in most suicides. So now we're in section 1, the law of homicide. Now, number 1, the killing by a human being. It is not homicide for a man to kill an animal, or for an animal to kill a man. See the caution there? If the killing be done by an ox, a dog, or any other thing, it is not properly termed homicide. An animal might be used as a means of committing suicide, as if one man on horseback should purposefully run down another on foot with fatal consequences. I never thought of that, because we don't live around horses day in by day out. But in such a case, the law attributes the killing to the human rider and declares it to be homicide for this reason. In fact, whether a certain loss of life was brought about by a human being is a problem of fact rather than law, as a matter of causation. By an arbitrary rule, in some jurisdictions, the law will not recognize a homicide unless the death has resulted within a year and a day from the time of an act which is alleged to have caused the death. In other words, death cannot be attributed to a blow or somebody striking them, which is preceded by more than a year and a day. In such case, the loss of life is attributed to natural causes rather than to the human act which occurred so long ago. The year and day formula was adopted in ancient times. Got a footnote here. For if he die after that time, after the year and a day, it cannot be discerned, as the law presumes, whether he died of a stroke or of poison. In other words, death cannot be attributed to a blow or other harm which preceded. Okay, we read that. When it was assumed that a period of time would be figured by including the day on which the event happens, which starts the running of the period, and the additional day was added to ensure inclusion of the whole year. When it came to be recognized that as a general rule, the day which starts the running is not itself counted in the period, the formula was retained with a qualifying explanation. Welcome to lawyer land. Following qualification. Are we doing theology or criminal law? You get a lawyer and a theologian together, and if the lawyer loves theology, boy, and I've had some lawyer friends, man alive. They love talking. Oh, I had one on a carrier. He'd come over every morning before a shift would start, talk theology in my office. Became a good friend. He's an elder PCA elder up in Maine somewhere. This language has been copied in some of the statutes. The rule was held to have been eliminated by judicial construction of the New York penal law, and has been judicially abrogated in New Jersey. The rule remains in force in some states, but the trend in most jurisdictions has been to repeal statutes embodying the rule, the year and a day rule, or leave the matter out of new codifications. The year and a day rule for homicide has been modified by a California statute that within 3 years and a day. So say you strike someone and he or she dies a year and 1 day later, or in California, 3 years and a day later, you can't be charged with that homicide. Now, what do you do within that period? Well, I'm sure they'll have an answer for that. The common law of a year and day rule does not conform to the present day medical realities, principles of equity, or public policy. We reject it as an anachronism and declare that it is no longer part of the common law of the state. That was a ruling by the New Jersey Supreme court. The new rule was held applicable to the defendant and his conviction of murder upheld, although the death was 63 days and a year after the shooting. So let's talk about death. From ancient times, the end of cardiac and respiratory functions has been accepted as the end of life. One is dead when the heartbeat and breathing have stopped once and for all, with a footnote. When the heart stopped beating and the lungs stopped breathing, the individual was dead according to physicians, according to law. And it's got a case here. One is dead. Okay, until recently, this has been adequate. But now that medical science is able to maintain cardiorespiratory systems in a dead body, it is not. It is very important for medical science to be able, by intricate machinery attached to the body, to cause the blood to circulate and respiration to continue after the body is dead. For example, the victim of a fatal accident or murderous attack may be the potential donor of a vital organ in order to save the life of another, and the continual flow of blood, constantly revitalized by breath, is necessary to provide the organ proper for transplantation. But because of this miraculous technique, it is essential to have another method of determining death. In a murder trial, this is the Commonwealth versus Golden, a Massachusetts case, it was shown that the defendant, just for kicks, hit a man on the head with a baseball bat. For kicks? Oh my. The victim was rushed to a hospital where a large portion of the front of his skull was removed to relieve pressure on the brain. He breathed with the aid of an artificial respirator. 2 days later, the respirator was momentarily disconnected and he failed to breathe. Blood pressure and pulse were not observable, and an electroencephalogram and other tests showed a total lack of brain activity. I'll refrain from comments on lack of brain activity, but it might apply to contemporary Christian music. Lots going on in that brain, but it's not theological or biblical thinking. Banging your head on a wall, hot metal music. Well, let's go on without my weak attempts at humor. Total lack of brain activity. So this guy got hit in the head. He was placed back on the respirator and taken off again 2 days later with the same result. The respirator was reconnected then, but was removed after a period of 2 more days. What's going on here? It was claimed that the defendant could not properly be convicted of murder because if the respirator had not been removed, the victim might have survived beyond the year and a day rule, so that the death could not be attributed to the blow inflicted by the defendant. See where this might go? They might have kept him. The year and day rule obtained, keep the guy in the respirator for a year and 1 day, and on the second day, pull the respirator, he dies. The guys can't be held accountable. The court dismissed this odd argument by accepting the brain death concept and holding that the deceased was already dead when the life-saving device was removed. In another murder case, this is State versus Fierro. It's an Arizona case. The defense was made by a more direct approach. It was claimed that the defendant could not be convicted of murder because the doctors had caused the death of a victim by removing the life-saving device. In short, that the defendant was not guilty of murder because the deceased was not killed by the defendant, but by the doctors. In rejecting the claim, the court said, quote, Because of increased interest in organ transplants, it was felt by some that a different definition of death was necessary. As a result, the National Conference of Commissioners on Uniform State Laws proposed the Uniform Brain Dead Act that was stated. I know we're talking about criminal law and the law of homicide, but the Uniform Brain Dead Act. I'm going off on a limb, and I cannot refrain from talking about all this goofy stuff with this 45 minutes. The Uniform Brain Death Act. If you love contemporary music, you won't enjoy my humor, but it's close. This is a very nice little metaphor. Brain Dead Death Act. Quote, for legal and medical purposes, an individual who has sustained irreversible cessation of all functioning of the brain, including the brainstem, is dead. The uniform law provides that a determination of brain death must be made in accordance with reasonable medical standards. The court then added, in the instant case, expert testimony was received that showed that the victim sustained irreversible brain death before the life support had been withdrawn. And in a civil case in which the point was involved, the court said, we hold that it is for the law to define the standard of death, that the brain death standard of death should be adopted, and that is for the medical profession to determine the applicable criteria in accordance with the standard medical practices for determining whether brain death is present. Or with our metaphor for theologians, to determine over here in practical theology if brain death has occurred with these little lyric boys and girls banging away, banging under tubs, 4 words, 4 chords, I should say. 7 words, we'll give them that. Might be 8 or 9 words. 10? I don't know, it's getting a little up there. 7 words repeated 11 times. 11 times? I thought it was 20. I remember going to one place, they sang 5 hymns, not hymns, 5 choruses, each of them about 6 to 7 minutes long. And they kept repeating the words over and over. There was no brain activity going on. It was more like people on cocaine jumping around. And anyways, back to it. As indicated, a brain death statute has been suggested some years ago. Some states have enacted the legislation. A reference here to the Iowa Criminal Code, Section 702. Has been suggested, but that was not true in any of the states in which the cases above were decided. Those cases were all decided as a matter of common law. One court purported to distinguish between brain death and common law death, but as it was acting without the benefit of a statute, the result it reached was common law. This is entirely proper because common law is sufficiently vital to adapt to new situations. One of the cases repeated that, quote, the rules and principles on common law are broad and expansive enough to embrace all new cases as they arise. There's a Massachusetts ruling on that. This being the quotation from Webster, the famous Massachusetts case. While perhaps in the nature of an overstatement, the message is clear. In dealing with an entirely different problem, the Michigan court gave this introduction to an important change. Quote, today we exercise our role in the development of common law by, and then there's a quote here. We now have the proposed Uniform Determination of Death Act, which is very simple and direct. An individual who has sustained either an irreversible cessation of circulatory and respiratory functions, there's the ancient definition, irreversible cessation of all functions of the entire brain, including the brainstem, is dead. A determination of death must be made in accordance with accepted medical standards. Adoption of this uniform act by all states would seem desirable. It is not indispensable as far as the law is concerned. Brain death has become part of common law. And now there's infanticide. That comes, and here in contemporary theology, look at what Governor Cuomo, that reprobate, authorized it, and that other Baptist reprobate in Virginia stood beside killing of infants. It's first-degree homicide. Let that sink in, brothers and sisters. State-sponsored infanticide. Media covering it, they did for a while, but then they move on to the next shiny object. The victim of a homicide or alleged homicide must also receive attention. The killing of an unborn child is not homicide, according to common law. Statutes in a few states have provided punishment under the name of manslaughter for killing of an unborn quick child, that is, a living child in the womb, under certain circumstances. There's a footnote to a New York statute and some case law. But most states follow the common law rule that there is no homicide of any grade unless the deceased had been born alive. Just what constitutes being born alive has presented something of a problem. The early view that to be born alive, the infant must be fully expelled from the body of the mother and have established a separate circulation. It must live apart from the body and circulation of the mother. It must have achieved an independent and separate existence or circulation. Some courts have required that the umbilical cord be severed. There's a case here in a Tennessee case, Morgan v. State. This was generally modified, however, by holding that it is sufficient if the child is alive after having been expelled from the mother's body, even if the cord had not yet been cut. A more advanced view, based upon practical considerations, rather than the literal meaning of the phrase, is that after the actual start of the birth process by a viable child, it is to be regarded as having been born alive for the purpose of the law of homicide. This draws a line between stillborn and born alive, limiting the former to those instances in which the fetus is dead before birth starts. Where such is not the fact, under this view, the killing of a viable child shall have the same consequences, whether it is during the birth process or after its completion. And you'll notice how the definition is going to exclude children in the womb. Infanticide we see in the Bible with the command to the Hebrew midwives to kill the children. Hebrew midwives lawfully resist the order of the reprobates trying to kill God's church. We see the same with Haman in the book of Esther, only that not with infanticide, although the rule was far and wide through 127 provinces from India down to Ethiopia, to kill all men, women, and children. So in the killing, in our view, of women, pregnant women, not just women in general, homicides, But pregnant women would involve the death of two, the mother and the baby. Haman nearly pulled it off. We read the great story of God's omnipotence in raising Mordecai and Esther to deliver the Hebrews from mass genocide and homicides. Homicides, plural. Back to the infanticide. Whatever the rule as to what shall be deemed to constitute live birth, the fact must be established by evidence. And while the newer holding removes some of the difficulties, it does not remove all. Well, I think we'll draw that to an end. This arises from watching Dutch Gilson post about the English reformers, but not just English reformers, but there were, even in church history, thousands of homicides in the first 10 imperial persecutions. Thousands of our brothers and sisters who went on to glory and are among the noble army of the martyrs, which we refer to in morning prayer and the Te Deum Laudamus, have died by other human beings, and that's the definition. A homicide is the killing of another human by another human. Now that's the broader definition, but we like the older definition. Homicide is the killing of a human by a human, so it includes suicide. We're talking about infanticide here. We see it in Exodus. We see its potential in the period of Esther and the horror of bloodshed that God has as the infinitely holy God. Now, they're not talking theology, are they? Not talking theology at all. And so we fault them for that. What else are they going to do? They're in secular law school where God is put outside, sitting in another room quietly. Although Blackstone's legal dictionary, that might be fun to read after this. So let's praise the one whose blood was shed by other human beings, but who rose, as Jesus' death was a first-degree homicide. And there's blood guilt on the hands of those who did it. Let's pray. Worthy is the Lamb that was slain, whose blood was shed, and who rose from the grave to receive power and riches and wisdom and strength and honor and glory and blessing. Hallelujah, Jesus. Well, we'll come back at it next time, God willing. Until then, Godspeed.